The defense of duress, like the defense of necessity, is an excusatory defense. In claiming duress, one does not deny that one engaged in wrongdoing. Rather, one claims simply that one's conduct was morally involuntary, and that it would therefore be unfair to punish the defendant for engaging in it. Necessity and duress are close kin, but they are not the same. And many of the differences can be attributed to the fact that, whereas necessity is a pure creature of the common law, the defense of duress is both a common law and statutory defense. This has produced, needless to say, a contorted line of authorities. At common law, it was traditionally accepted that the defense of duress would be available only where the defendant received a threat of death or serious bodily harm and had no safe avenue of escape. By contrast, consider the text of Section 17 of the Criminal Code, which sets out the statutory defense. Here is Section 17 of the Code, and notice what it says. It says, "A person who commits an offense under compulsion by threats of immediate death or bodily harm from a person who is present when the offense is committed is excused for committing the offense if the person believes that the threats will be carried out, and if the person is not a party to a conspiracy or association whereby the person is subject to compulsion." But this section does not apply where the offense that is committed is, a number of offenses follow, including high treason, treason, murder, piracy, attempted murder, sexual assault with a weapon, threats to a third party or causing bodily harm, aggravated sexual assault, forcible abduction, and so on. Now, notice some salient features of Section 17. Like the common law defense, the statutory defense is available only where the defendant is subjected to threats of death or bodily harm. But unlike the common law defense, the text of the statutory defense suggests that it is available only where the threat is immediate and where the person issuing the threat is present when the offense is committed. Even if there is no safe avenue of escape, the text of Section 17 rules out claiming duress where these immediacy and presence requirements are not met. Furthermore, the defendant must not have been a party to a conspiracy or a member of an association and thereby made himself vulnerable to threats of death or bodily harm from his or her co-conspirators. Again, this limitation on the defense of duress is not to be found in the traditional common law defense. Moreover, Section 17 sets out a, as we've seen, long list of offenses for which the statutory defense of duress is simply not available at all. These offenses, as we saw, include murder, sexual assault, and a range of other offenses. And again, these limitations are not necessarily built into the traditional common law defense of duress. Now, in at least one respect, the statutory defense of duress may be regarded as arguably wider than the traditional common law. Whereas it is enough for the defendant to believe that the threat will be carried out under Section 17, under the traditional common law, there's some inquiry into the reasonableness of the defendant's belief. All things considered, though, the statutory defense is, on the face of it, much narrower than the traditional common law defense of duress. This has led to questions about whether and how the statutory and common law defenses can coexist. And so begins a long and tortured odyssey. Our story begins with a Supreme Court of Canada decision called Carker. Mr. Carker was charged with willfully damaging public property after damaging property in the prison cell in which he was inhabiting. He argued that he acted under duress because he was threatened with death and serious bodily harm by fellow prisoners during a riot. He claimed that the prisoners who were in adjoining cells demanded that he smash the water pipes in his cell, or that, quote, he would be kicked in the head, his arm would be broken, and he would get a knife in the back at the first opportunity. Now, Mr. Carker wants to claim the common law defense of duress. But the Supreme Court says no. He can't do that, the court says. And he can't do that ostensibly because Section 17 of the Criminal Code, as it were, occupies the field. It has ousted the common law defense of duress, and therefore Mr. Carker, if he wants to claim duress, must go through the statutory scheme and satisfy the statutory conditions laid out in Section 17. What's the practical effect of that? Well, the practical effect is that Mr. Carker can't succeed in his claim of duress. Why not? Because remember, the immediacy and presence requirements in Section 17, the threat of death or serious bodily harm must be immediate. And what's more, the person or persons issuing the threat must be present at the time the offense is committed. And, of course, Mr. Carker, who is in his cell, is not subject to immediate threat of death or serious bodily harm, and the other prisoners are in their cells, so they are not, strictly speaking, present at the time he commits the offense. So the statutory defense of duress simply won't work for him. He can't succeed in making that claim. Now, importantly, Carker was a case in which the defendant was the principal actor. It was he who damaged the property. He didn't simply aid or abet another person. What about a case where the defendant is a party to the offense? Does that make a difference? In Paquette, the Supreme Court says yes. Because Section 17 uses the term commits, the Supreme Court holds that Section 17 applies only to principal actors and not parties or accessories. Now, we can question this line of reasoning. Section 21 sub 1 defines parties as encompassing principals, and indeed says expressly that a party includes one who actually commits the offense. But let's set that point aside for now. What does this mean for parties? Since they can't claim duress under Section 17, which ostensibly only applies to principal actors, does that mean that parties have no access to the defense of duress at all? No, says the court. It just means that they must rely on the common law defense of duress. But wait, you ask, didn't the Supreme Court in Carker say that the common law defense of duress had been ousted by Section 17? That Section 17 occupied the field? Well, says the court in Paquette, yes. But the issue in Carker was availability of the defense for principal actors, not parties. So we weren't really talking about parties at the time. So in other words, they were able to distinguish Carker away. Section 17 does indeed occupy the field, but only where principal actors are concerned, not parties. The central issue in Rusage stems from Paquette. Principals, we have seen, could only make use of the statutory defense of duress in Section 17. And, as we have also seen, the statutory defense was in important respects narrower than the common law. In particular, again, as we've seen, the statutory defense requires the threat to be immediate and the person making the threat to be present at the time the offense is committed. These requirements were insuperable barriers to the defendant in Rusich. In Rusich, the defendant was charged with importing 2 kilograms of heroin. She admitted the importation. She admitted that she'd brought the heroin into Canada, but claimed the defense of duress. At the time, she was a resident of Belgrade in the former Yugoslavia, which was in the midst of a civil war and was subject to control by large paramilitary groups engaging in organized crime. Folks in Yugoslavia believed that the police could not be trusted and that the rule of law had effectively broken down. Our defendant in Rusich had been accosted several times by an individual named Merkovich. This person would repeatedly talk to her, reveal knowledge of her life, physically assault her, and threaten her mother. And one day, he ordered Ms. Rusich to import 3 packages of heroin to Toronto and said that if she didn't comply, he would harm her mother. Now, does this allow her to claim duress? Well, first, note that Ms. Rusich was the principal actor. It was she who brought the heroin into the country. So if she's going to claim duress, she must do so under the statutory defense of duress, Section 17. What does that mean? Well, it means she has to establish, among other things, that the threat was immediate and that the person making the threat was present at the time she committed the offense. But the threat was not immediate. The threat would be carried out at some remote location, remote to Canada, that is, and it would be carried out at some point in the future. Furthermore, plainly the person making the threat was not physically present alongside Ms. Rusich at the time she was importing the heroin into Canada. So what we have here is a situation in which Ms. Rusich can only claim duress via Section 17 of the Code. She cannot satisfy the immediacy and presence requirements of Section 17, and yet it seems difficult to believe intuitively that Rusich had any real choice but to comply with the threat. So what do we do here? Well, Ms. Rusich challenges the constitutionality of Section 17 of the Code. She, and specifically the immediacy and presence requirements of the in Section 17. And what ultimately happens is that the Supreme Court concludes that it is a principle of fundamental justice that we cannot imprison someone for doing an act in circumstances of moral involuntariness. And to the extent that Section 17's immediacy and presence requirements allowed for the possibility of someone being convicted under circumstances of moral involuntariness and imprisoned on that basis, the court finds that they must be severed from Section 17, essentially chopped out of Section 17. Now, in a moment, we're going to see that this created new problems for the law of duress. For now, though, let's consider this idea of moral involuntariness. Recall that, well before Rusich, the Supreme Court had recognized the idea of moral involuntariness. It underpins not just the defense of duress, but the defense of necessity. The core idea is that, under some circumstances, the moral pressure on a person to commit a criminal offense is so great that it is, in some sense, no longer possible to describe it as voluntary at all. We are drawing a kind of loose analogy to physical involuntariness. Just as we would not convict a person of assault merely because someone else physically manipulated the defendant's arm, neither should we convict someone who is told, "Commit this crime or I will hurt or kill you or someone close to you." In neither case, the intuition goes, is there a genuine choice by the defendant. But the analogy between physical and moral involuntariness is obviously imperfect. After all, the defendant whose arm is physically manipulated has literally no choice over how the arm is used. But the defendant who is threatened does have a choice, albeit a deeply unhappy one. He or she can choose, in a non-trivial sense, to let the threatener carry out the threat rather than break the law. So why treat this threat as exculpatory? If it isn't really involuntary in the full sense of that word, do we think the defendant should be acquitted because in committing the offense, he or she was not morally blameworthy? Well, the Supreme Court has insisted on several occasions that the answer to that question is no. In Hibbert, the Supreme Court denied that duress, at least typically, negates the fault element for criminal offenses. Duress, the court said, does not negate blameworthiness, but the moral voluntariness of the act. And this point is reiterated in Rusich. There, the court emphasized that duress doesn't negate the actus reus or fault elements of criminal offenses. Now, to a degree, this just underscores the fact that moral involuntariness and physical involuntariness aren't the same, since the latter does, as we've seen, negate the actus reus. So, to some extent, this point in Rusich serves to underscore the fact that moral involuntariness and physical involuntariness are related but not the same. But it also underscores that the defendant who acts under duress nonetheless engages in wrongful conduct. Breaking the law in the absence of a justificatory defense is wrongful and blameworthy, whether or not the defendant was subject to threats by others. So moral involuntariness is ostensibly not the same as moral innocence, nor is it the same as actual involuntariness. But the court in Rusich holds that it is a principle of fundamental justice that we cannot punish people for morally involuntary conduct, and on that basis severs the immediacy and presence requirements from Section 17. Now, this left a significant hole in the statutory defense. It cannot be the case that one can claim duress merely because someone makes vague threats of death or bodily harm, and the defendant honestly but unreasonably believed they would be carried out. Yet, once you remove the immediacy and presence requirements from Section 17, that's in effect what Section 17 then says. So, how to fill that gap? Well, by effectively reading into Section 17 some of the requirements from, you guessed it, the common law defense of duress. In particular, the Supreme Court in Ryan would read in first the no safe avenue of escape requirement. It would also require a close temporal connection between the threat and the crime, though not immediacy, and it would require the crime committed by the defendant to be proportionate given the threatened harm. These are in addition to other requirements. The result would be a demanding test for statutory duress, but a more flexible test than had existed in Section 17 prior to Rusich. Indeed, this flexible test, when combined with the purely subjective test set out in the text of Section 17, would be much wider than Parliament could possibly have intended when it enacted that provision. And so the Supreme Court did a little bit more tinkering. It found in Ryan that the defendant's belief that the threat would be carried out must be not just honest but reasonable. And the practical effect of all of this tinkering is that the statutory defense of duress now looks identical in most respects to the common law defense. It also means that the so-called statutory defense, in fact, bears no resemblance whatsoever to the statutory text of Section 17. The story of duress in Canada is an embarrassing comedy of errors. The very idea that Parliament would intend two different duress regimes, one for principals and one for parties, is, in the absence of far clearer language than was identified in Paquette, surely absurd. Leaving that aside, if Section 17 was really unconstitutional as written, as the Supreme Court found in Rusich, well then, the answer was not to rewrite the statute, but to just strike it down. And make no mistake, there are still questions to be answered. In Ryan, we have seen, the Supreme Court unified the statutory and common law defenses of duress in most respects. But recall that Section 17 bars principals from claiming duress where they are charged with one of several listed offenses. And again, these include, but are certainly not exhausted by, murder and sexual assault. Now, are those exclusions constitutional? Can Parliament block defendants from arguing that, for example, they should be acquitted for, say, murder on the basis that they were told, kill this person or I will kill you or your family, and that therefore their conduct was morally involuntary? Is it constitutionally permissible for Parliament to block murder defendants from making that argument altogether? In a case called Willis, the Manitoba Court of Appeal upheld the statutory exclusion of duress in cases of murder, largely on the basis that it could never be proportionate to kill another person in response to a mere threat of death. There is, the Court of Appeal suggested, always a reason to resist and hold out, since, if nothing else, the threatener might change his or her mind and not follow through with the threat. But the question of constitutionality is far from settled, even in the context of murder. And never mind all of the other offenses that are excluded under Section 17. And there's a flip side. What about the common law defense of duress, which seems to have no exclusions at all? Is that right? Can you claim duress at common law for being a party to simply any offense? Can a party, say, to murder, claim duress? Well, in a case called Aravina, the Ontario Court of Appeal said yes. There may be cases, the court said, where a defendant genuinely had no realistic choice but to yield to threats and thereby aid or abet the offense of murder. Again, though, this question remains very much on the table. In this lecture, I've sought to explain the peculiar evolution of the defense of duress in Canada. See you next time.